Lying and saying the truth in contracts are not really subject to moral codes. In fact, most of these just come down to technicalities. Let's talk about that. So if you're new to this channel, hi, welcome to The Right Network. I'm Moses, and in this channel, we are all about business, legal stuff, procurement. Basically, it's an educational channel, and kindly do subscribe and hit the notification bell to be notified. In fact, if you know anybody would benefit from some of the content we put, help us, okay? Share the link with them, help the channel to grow. Now let's talk about the topic of the day. During the negotiation phase, okay? When you're negotiating a contract or whatever it is, but for the most part, if you're negotiating a contract, there are a lot of things you say. Some of those things tend to be true, some of them are going to be false. The idea is you're saying these things with the hope that they will get to become part of the contract, or they're saying this thing because you just want the other person to get into a contract with you. So the things you say during this phase, during the negotiation phase, are called representation. And if they happen to be part of the contract, they're going to become terms of that contract. Now, supposing those things are false, then you call them misrepresentation. But then the question is, must you always say the truth in a contract? And the answer is, well, it depends. It depends on the misrepresentation, or the lie in this case, okay? The effect that lie has in a contract. Representation is a statement of fact made to induce the contract. Such statement relates to some material aspect of the contract. And as I've already pointed out, if that is false, then it's called misrepresentation. It is worth noting that during the negotiation phase of a contract, material statements made may either be, number one, statements which form the express terms of the contract, and if those terms, okay, which are supposed to be part of the express terms in a contract, if they are untrue, then they're going to be considered a breach of a contract. And the problem with a breach of a contract, of course, it will depend on the nature of the breach. If the breach is a breach of a term that is actually a strong term, the entire contract is off. If it is a breach of a minor term, okay, a warranty, then, there are things that you're going to do, like paying damages. Number two, statements which do not form part of the contract, but which helped to induce the contract. Such statements are mere representation, okay? And if they're false, now they become misrepresentation. So even before we go ahead, you straight away start to realize that the lie you tell in a contract or the truth you tell in a contract will depend. So if the lie, you lied about something and the other party expected that whatever you said to constitute an express term in that contract, and the term is actually a strong term in this case, then see, that's a breach of a contract. On the other hand, if the statement you made, in this case the statement happened to be a lie, it's one of those lies that isn't really going to be forming a major part in the contract, then you see, you can start to get away with that, right? So let's continue. And if at any point here you're probably thinking, I'd like to know more about contracts, there's a link in the video description which will take you to one of my series of videos, okay, training you on contracts. So you can check that one out. What are the requirements of misrepresentation? So you just can't run to court and say he or she or they lied to me. Okay, there are certain things that have to be there. So let's talk about those requirements, because for misrepresentation to be actionable, certain things must exist. First one, it must be a statement of fact. In short, it should not be some vague reference without effect or some statement of an opinion. It has to be a statement of fact. Look at this example. So if a vendor of a farm, which has never been used as a sheep farm, stated that in his judgment, the farm would support 2,000 sheep. What is that? Is that a fact? Is that an opinion? Of course, let me know that in the comment section. But you straight away start to see that certain statements, okay, whether the statement is a lie or truth will depend. If it is a fact and you've presented a lie as though it were a fact, then of course you see that affects the contract. If it is an opinion, then, well, it is an opinion. Now, number two, it must not be a misrepresentation of the law. Number three, it must be an active representation. As in, that statement should be the kind of statement that actually makes you do something in the contract. So if somebody lies to you in a contract, okay, and it's like one of those things that you get caught up in if you're looking for a job, and then you start negotiating and they tell you, here's a starting salary, X amount, And then as time goes by, you will increase the amount, and then you're like, yeah, sure, cool. Well, when you sign the contract, just sending a contract with the number that you agreed to. Whatever they said, that is not a fact, that is just opinion. As time goes by, we shall increase. What does that even mean? So you see, you're not getting the job because of the as time goes by. You're getting the job because you've accepted the number that they gave you, the number that is in the contract. And that is the reason why it must be an active representation. So the question is, must you always disclose the truth in a contract? Now, you have to understand that a party to a contract is under no obligation to always disclose the truth. Meaning what? Meaning you're not always required to say the truth in a contract. Of course, I'm saying that, but there are moral implications. It's just that when we look at formation of the law, okay, there's the question of law, morality, and ethics. Some things are legal, but they seem immoral, okay? And some things seem to be immoral, but they are pretty much legal. I mean, for example, if you are speeding, okay, because your child is sick, well, you're still violating traffic laws, right? So there is that area there. The police might say, I'll just let you go because, I pity you as a human being and I'm a human being. But that doesn't really mean that whatever you're doing becomes legal, okay? And yet everybody else will think he's a good parent, or he's a good whatever it is that he is that, makes them want to take that child very fast to the hospital. So you need to understand that about the law, okay? And so regarding the truth, or regarding lying, okay, the question of must you always tell the truth will depend on the following circumstances. Number one, remember this is still part of number three, right? Number one, where there is a fiduciary relationship, e.g. principal-agent relationship. In that case, you have to disclose the truth. Number two, where circumstances have changed since a representation was made, okay? You agreed on one thing, and then as time goes by, that thing has changed. So the change has to be reflected. You have to let the other party know that this thing has changed ever since we agreed. We agreed that you are going to use this car for 2 days. But then something has happened, okay? And now you can only use it for, maybe I want to use it for 3 days. Now I have to let you know that. So I have to tell you the truth in that case. Number three, in contracts of utmost good faith or uberimai fidei, in that case, full disclosure is mandatory. Example here will be insurance contracts, okay? And so that is why in most cases, the insurance people will probably just know that you're lying to them, don't do anything because you're giving them the premiums, and then the day you're like, no, I want to be paid, they'll be like, no, you haven't told us the truth in this contract. You breached the contract. It's just one of those crazy things that people do in contracts to take advantage of other people. And last one, partial disclosure, okay? So if you're going to say half truth, then you just have to say the entire truth. There is nothing like half truth, okay? So it's either you don't disclose or you disclose. Now, number four, as part of the things that, guide us as far as misrepresentation is concerned. Number four, it must have been a material inducement. That is a matter which actually made the other person to do something, okay? So whatever I told you, the lie that I told you, actually made you do something in that contract. So you got into a contract as a result of what I said. And so any other reasonable person who hears that would also do the same thing. So it must be a material inducement. Of course, there are exceptions to this. For instance, where the misrepresentee or his agent actually knew the truth, where the misrepresentee was ignorant of the misrepresentation when the contract was made, okay? Or number three, if the misrepresentee did not allow the misrepresentation to affect his judgment. So, regarding saying the truth or lying, now you have it. But before we finish, here's something else we need to understand. There are three types of misrepresentation. Or there are roughly three types or three scenarios under which the lie can come up in a contract. So these are going to be number one, fraudulent misrepresentation, okay? So in the case of a fraud, where somebody, I'm just lying to you and you don't know that I'm lying to you, and the whole thing is just because of a fraud that I'm actually getting involved in. Number two, innocent misrepresentation, where you actually say something believing that thing to be true, and yet it turns out not to be true. So in that case, it's innocent, okay? You didn't intend for, you honestly believed in whatever it is that you are saying, okay? It's like if I say, well, we are going to have a class in the afternoon, and we both know that we're going to have a class in the afternoon or something like that, and then I get caught up in traffic, or I get arrested for something, driving recklessly, and that's pretty much kind of puts an end to the class. So you might say, well, you lied to us. Not really. When I told you that, I honestly believe that you're going to have the session. Now, last, negligent misrepresentation, which can also be referred to as negligent misstatement. Of course, if you prove that, then the other person becomes liable. So, if there is any question, do let me know. I'm Moses from The Right Network, and I'll see you in the next video.